Good morning and welcome to today's webinar titled Porridge or Freedom Fries, an essential guide to sanctions compliance. On the 24th of February of this turbulent year, life changed dramatically for many when Russia invaded Ukraine, triggering a multilateral response unseen since World War II, with international sanctions forming a key component, leaving many scrambling to ensure their compliance in a complicated and evolving field of law. Fortunately, today we are joined by Fergus Randolph QC, who will demystify it all for us, providing an overview of the UK's regime in terms of sanctions, identify key problem areas, and conclude with suggested best practice to follow. Fergus practices commercial, EU and international law in London and Brussels, and has been involved in sanctions litigation for many years, initially dealing with Iran and of course most recently with Russia. He is a bencher of Middle Temple and chair of the Bar Council's International Trade Working Group. Before Fergus kicks things off, I have some brief housekeeping points for those who are new to our webinars. I'm Charlotte Dorber-Ashley and I manage the FS Club here at ZM. And I would like to warmly acknowledge our very generous sponsors who enable us to continue to bring you a wide range of thought-provoking content across finance, technology, economics, and even international law. The slides for this presentation will be publicly available on our website and in the chat box. The session will be recorded and available to watch on our website within 48 hours, and we'll be holding a 20-minute Q&A session. So please use the GoToWebinar chat facility to send your questions in to me so I can feed them into the conversation. Now, it's my pleasure to hand over to you, Fergus.
Thank you so much, Charlotte, and good morning from London. I understand that we have attendees from Hong Kong and New Zealand, so it won't be morning for you. It's day 154 of Russia's invasion of Ukraine, and as Charlotte said, since the 24th of February we've seen an unprecedented set of sanctions imposed by many countries against Russia. In the past, sanctions regimes such as those involving Iran, Syria, Libya have had obviously an impact on the designated countries and people within them, but less so in terms of businesses and professionals in the UK, because there simply wasn't the depth of business relationships between London and those countries and people there. Russia's invasion, on the other hand, has laid bare the deep and entrenched economic ties with other countries, most notably insofar as Europe is concerned, and most notably there in the energy sector, and most notably there, Germany. And this coming winter is going to be complex, to say the least. I would suggest that the UK, the EU, the US and other countries, New Zealand, Australia, Canada, have worked really hard and very effectively to present a common position in response to Russia's invasion. Whether that position lasts and for how long is anybody's guess, but I think we need to cross our fingers on that. Now, before I get into my talk proper, I'm going to ask two questions just to see whether you have a feel for where we're at and where the sanctions are at the moment. So the first one, can an accounting firm in the UK provide auditing services to persons connected with Russia? So yes, no, or unsure. So if you could fill those in, that would be helpful.
We'll just leave that up for a minute while everyone answers.
Sure, thank you. Oops.
Wow, that was quick.
That was good. So for yes, we've got 43, no 17, unsure 39. Well, I think that tells its own tale in a way. It's a little bit of a trick question because this professional business services were impacted by the 14th Amendment to the regulations last Thursday. So that's quite recent. And although accounting review services are prohibited, so the wording of the regulation is a person must not directly or indirectly provide to a person connected with Russia accounting services exclude, or rather they include the review by a person of annual and interim financial statements and other accounting information, but exclude accounting auditing services. They include compilation of financial statement services, and they include other accounting services such as attestations, valuations, preparations, and bookkeeping services, but they specifically exclude auditing. So for those of you that said, yes, you were right, no, you were wrong, unsure, well done, because it only came in last week, although it had been on the agenda for some considerable time. Could we have the second poll question up, please? So can a UK PR firm with an agency in France provide advertising services from that agency for someone connected with Russia?
Just leave that up for a moment longer. I think everyone's nearly done. Quite a complicated, getting a bit complicated now.
Okay, so yes, 8% interesting, no 54, and unsure 38. Thank you to all those unsures, because you are being honest. I'm not saying the others aren't, it's just, you know, it's nice when people actually admit they don't know. The answer is probably you can. The reason is that essentially public relations services, which are prohibited, a person mustn't directly or indirectly provide to a person connected with Russia public relations services. They're defined in 54B little c as services provided by a person related to improving the image of their clients and their relationship with the general public and other institutions, but excludes planning and creating services for advertising or public opinion polling services. So does the provision of advertising services, is that caught by creating services for advertising? I don't know. Personally, as this only came into force last Thursday, it hasn't been tested. All this is to show that the regs are clear in part, but not wholly clear. And the problem is that a breach of these regulations is an offence, is a criminal offence. Maximum penalty, 10 years inside. So that's why I said porridge. You do porridge, you do time. Now, it's extremely unlikely that professionals are going to find themselves in this position, because you will all take advice, and we will make sure people who are advising look at these things carefully, talk to the relevant authorities, which in this country is OFSI, and I take my hat off to them. They've started from a pretty low patch in terms of numbers. They've ramped up, they've done a hell of a lot in the last 154 days, and they've got a lot more to do, but there's a lot on their plate, so there are delays. But essentially, you do need to understand that, as we'll see in a moment, that these sanctions are extremely widespread and wide-ranging, and potentially the impact of a breach may not land you 10 years inside, probably wouldn't, but it would do massive reputational damage, which is why a number of people have been seeking my advice over the last 154 days. Professional people, solicitors, other lawyers in other jurisdictions, they are very concerned, and quite rightly, on behalf of themselves and their clients who may be impacted. Because if you get the wrong side of these sanctions, which no one willingly wants to do, I would suggest, then the ramifications can be very serious. Could we have the and so thank you for filling in the slides, in the questions. Thank you. Now the roadmap, we're going to trot through this quite quickly, because I just want to, the key takeaway that I want to give you is that I want you to know, not the answer, but there's an issue. So if there is an issue, you know, gosh, I've got to talk to someone, look at it, ask advice, whatever. The worst of all worlds is to just blithely carry on, not even knowing that there's an issue. And to be fair, up until last Thursday, there wasn't an issue with regard to PR and accountancy services. So that's the other point. You not only need to know there's an issue, but you need to keep your eye on the ball. As I say, there have been 14 amendments to the regulations, and essentially you need to plug yourself into someone or something that will keep you up to speed insofar as you are likely to be impacted. Now, very quickly, the position pre and post Brexit. Pre-Brexit, we were obviously in the EU, and essentially the sanctions regime was governed by the EU. It was impacted by all the member states, and the sanctions are passed on a unanimous basis, but essentially we were part of that particular club and therefore didn't have our unique individual sanctions regimes in this country. Post-Brexit, that has changed. Obviously, the Office of Financial Sanctions Implementation, which is part of the Treasury, was set up in 2016 to provide a high-quality service to the private sector, working closely with law enforcement to help ensure that financial sanctions are properly understood, implemented, and enforced. And in 2018, the Sanctions and Anti-Money Laundering Act was passed, giving the UK continued ability post-Brexit to implement UN sanctions regimes and to use sanctions to meet national security and foreign policy objectives. Very quickly on the EU position, there's an important case called Cardi, where before that, essentially the EU courts, so the General Court and the main court in Luxembourg, were saying, "Ooh, it's very political, we don't deal with this." Post-Cardi, they're saying, "Oh, okay, human rights matter," and I had lots of interesting cases on behalf of Iranian clients, essentially pointing out the errors in the decisions and getting a lot of those decisions lifted. However, as it happens, about 5 minutes ago, popped into my inbox a press release from the General Court, which sat en banc, so with all its members, in Luxembourg. So the General Court is the High Court, if you will, of the EU. And they turned down, as far as I could see, or did not permit a challenge to the designation by the EU of France RT, or RT France, which is the Russian communications, sort of equivalent to the BBC or whatever. And they've been designated, and they raised all sorts of arguments. I haven't read them all, but I saw that the challenge was unsuccessful, basically. And the first paragraph was, "We live in dangerous times," and essentially there's a wide degree of discretion. So that's interesting. I haven't read the judgment, obviously, but just to say, it looks as if the post-Cardi landscape has changed in favor of the designating authorities, so the member states, and essentially by reflection us as well in the UK, and to the detriment of the designated entities. So that's important. OFAC, very quickly, the US, I'm not going to spend any time really on this. It's just, if you really don't want to get on OFAC's radar, OFAC is the equivalent of OFSI in the States. It's super bad news. You just wouldn't be able to trade, do any business. You could probably be arrested if you flew in. So essentially, all of you are obviously law-abiding and will take sensible advice. Don't, even if you were tempted to risk it, please don't. And definitely don't insofar as the States is concerned. Could we have the next slide, please? Thank you. Now, again, I can trot through this quite quickly. These are, I'm not going to go through each and all of them. I've discussed the Sanctions and Anti-Money Laundering Act. The regulations are the ones that I was discussing, amended 14 times. The Economic Crime Transparency and Enforcement Act is interesting because it came in about a month after the invasion and was was very quickly adopted, went through Parliament without a problem, and essentially allowed the UK to coattail, if you will, on other jurisdictions who were already designating other entities without the need to go through the usual procedure. So they created what they call an urgent procedure, where you could just coattail or piggyback on other EU regimes, other international regimes, allowing quicker designations. Because you probably remember at the start, it was a bit like a sort of Formula One race. The first car was going fast and in front, and then all of a sudden there was an overtaking maneuver. So in other words, the UK started quite fast, and then the EU took over, then the US took over, and we were slightly behind. So that was good, and the Economic Crime and Transparency and Enforcement Act sorted that out. It also, as is obvious from its wording, deals with transparency in terms of beneficial ownership, and so there are going to be some important changes there going forward, because obviously what has come to light, if you will, is a lot of people who have been designated and have had beneficial ownership structures out in places like the BVI, which are not terribly transparent. So that's going to change. We've dealt with OFSI, and we've dealt with the breach consequences, severe, doing time, Porridge. Courts, challenges to designations. Well, at the moment, there haven't been any, as far as I'm aware, in the UK. There've been a sort of minor skirmishing. Mr. Abramovich has brought a challenge in the General Court on the 25th of May, so that has yet to be heard. And we've just seen that the RT France case was obviously the challenge was brought and has been determined against RT France. So watch this space. I would be very surprised if there weren't more challenges. I simply don't know how successful they'll be. They're very fact dependent. Next slide, please. So this sets out essentially the regulations in relation to first of all, the financial sanctions, so that's 11 through 18. And I don't know whether the people in the audience, the virtual audience, are involved in financial matters, but the odds are that someone is. Essentially, the key regulation, I'm not going to go through this in great detail, you can look it up online, but the key regulation is Regulation 11.1. So a person, that's you essentially, must not deal with funds or economic resources owned, held, or controlled by a designated person, so that's someone who's been sanctioned, if P, so you, know or has reasonable cause to suspect that P is dealing with such funds or economic resources. Now, you then ask yourself, well, what does dealing with mean? And I've spent lots and lots of hours advising on this. 11.4 sets it out, and it's really wide. So a person deals with funds if the person A, uses, alters, moves, transfers, or allows access to funds. B, deals with the funds in any other way, very wide, that would result in any change in volume, amount, location, ownership, possession, character, or destination, or makes any other change, so another very wide point, including portfolio management that would enable the use of the funds. Same point in relation to economic resources, and essentially economic resources are anything that aren't funds that have a fungible value. Ownership is very critical because obviously that's the trigger, because this only impacts if the funds or economic resources are owned, held, or controlled by a designated person. They're owned controlled, and this is Regulation 7, if the person in question holds directly or indirectly more than 50% of the shares, or holds directly or indirectly more than 50% of the voting rights in the relevant entity, or holds the right directly or indirectly to appoint or remove a majority of the board of directors. And then you've got to look at Schedule 1. So that's the first condition. The alternative condition to be met, which is pretty wide as well, which means that you can show that it's owned, controlled, or directly or indirectly by a designated person, is, so this is the second alternative condition, is that it is reasonable, having regard to all the circumstances, massively wide, to expect that the individual would, if that individual chose to, be able, in most cases, very vague, or in significant respects, very vague, by whatever means, incredibly vague, and whether directly or indirectly, totally open, to achieve the result that the affairs of the other party are conducted in accordance with his or her or its wishes. So this is where, for example, a designated person, let's say an oligarch, used to have 50% or more beneficial ownership in something, and then took it down to 49% and gave, or even, you know, lower, 25%, and then gave the what had been his or her or its shareholding to his or her children or relatives or whatever. And then there might be a suggestion that in that case, essentially the designated party entity would be able to essentially ensure that his wishes, his, her, or its wishes were upheld. So again, very large degree of subjectivity. You can get licenses, I'll do this very quickly, from OFC. They're governed by Regulation 64, quite complex to get the licenses. Normally it'll be in relation to asking people like me to be paid, but also it's for living expenses and various other things. At the moment, it's taking a very long time indeed. Could we have the, you've got, yeah, that's fine. At the bottom, information and records, there are various obligations on professional service providers to give information and records, but it won't be of massive interest to you. I put it in there for completeness. Trade licenses are the same for Treasury licenses under 64. We'll come to trade in a moment. Is governed by Regulation 65. Could we have the next slide, please? Thank you. Now this is trade, and so we've done finance, and so you can see here the type, the scope, the ambit, the width, the breadth of the sanctions. So can't deal with restricted goods, which essentially be things that could be dual-use weapons, energy-related goods and related activities, aircraft and ships, luxury goods, I've advised quite a lot on that, iron and steel products, internet services, and as we've seen, professional and business services, which, as we haven't dealt with all of them, but essentially 54C says a person mustn't deal directly or indirectly, must not directly or indirectly provide to a person connected with Russia accounting services, business and management consulting services, or PR services. And then you get to 3, a person who contravenes any of the prohibitions commits an offence. And then you go back, in fact, you go forward to see what that is, and that'll be that the maximum is 10 years. So it covers a lot. There's also ships, specifically further on, and aircraft. It's a bit higgledy-piggledy because this has been built on over the 14 amendments to the regulations. Essentially, to begin with, it was very, very, it was very tight, and since then, things have widened out, in particular in relation to oil, not so much gas, but oil transported by ship, and they had specific provisions in relation to luxury goods and other matters. There was something in the press saying that luxury goods covered by the EU sanctions would not include, or luxury goods / gold, which was another new product covered by the sanctions, wouldn't cover jewellery because they wanted to safeguard the jewellery businesses in the EU. That wasn't the position. Both the UK and the EU are lined up on that, so jewellery is covered up above a certain amount. So very ordinary cheap jewellery will not be covered. Just wanted to deal briefly with what is, because you will have noticed that the trigger is providing services to a person connected with Russia. So Regulation 21.2 defines that, and it's defined as being 1, an individual who is, or an association or combination of individuals who are ordinarily resident in Russia, so that's fine. 2, an individual who is, or an association or combination of individuals who are located in Russia, so resident, located, these are all alternatives. 3, a person other than an individual, which is, so a corporate entity, which is incorporated or constituted under the law of Russia, that's quite clear. Or 4, a person other than an individual, so a corporate entity, which is domiciled in Russia. So it's quite wide-ranging, and given the city's links to Russia and Russian interests, just shows that these sanctions can bite in a very wide fashion way. Can we go to the next slide, please? So just very briefly, in terms, because the EU regime, as I said, essentially the UK, the US, the EU, Canada, Australia, New Zealand, etc., are basically on the same page. There's a framework regulation which provides the general framework, or provides the general framework for the EU sanctions imposed in respect of actions undermining or threatening the territorial integrity, sovereignty, and independence of Ukraine. It covers finance, trade, etc. The framework regulation applies within the territory of the EU, including on board any vessel under the jurisdiction of an EU member state, so flagged. It only applies to natural persons wherever they're situated who are nationals of a member state. It applies to any company wherever it's situated, which is incorporated or constituted under the law of a member state, or in respect of any business done in whole or in part within the EU. Now compare and contrast that with the UK scope regulation, which is Regulation 3. So a UK person, that's a resident or a company, may contravene a relevant prohibition, we've seen what some of them are, by conduct wholly or partly outside the UK. So you could be a UK business, wholly transacting or involved in service provision, whatever it is, outside the UK, but covered. So it's got an extraterritorial limit to it. And then a person may contravene a relevant prohibition by conduct in the territorial sea. So that's quite wide. And it also says at little 7, nothing in the regulation is to be taken to prevent a relevant prohibition or relevant requirement from applying to conduct by any person in the UK. So it's just to make sure that you don't misunderstand that it applies within the UK, obviously, but also in an extraterritorial fashion, which is quite important. So you can't escape the regulations simply by virtue of you operating in another country outside of the UK. So could we have, so I've done the jurisdiction, 6 sanctions package, it's now 6.5 essentially. So that was oil and not really gas. They met, I think the foreign ministers met yesterday or the day before, and essentially have said we're going to keep these sanctions going. but essentially the large part of that meeting was political in relation to the package to slow down use of energy consumption within the EU, and although they wanted 15% reduction, essentially the FT today seems to have calculated that it's gone down to about 10 with all the carve-outs. But anyway, they've done pretty well given the fact that a large number of countries weren't very keen, especially the Southern European ones weren't very keen. They've been beaten, they've been punishment beaten during the financial crisis of 2008 by Germany, and they didn't feel any need to bail Germany out. Anyway, they've come to some form of agreement, and that's impressive. It is necessary to understand that, as I said earlier, sanctions legislation at the EU level has to be passed unanimously, which obviously is complex politically for fairly obvious reasons. There's the implementing regulation, which is that one, which essentially goes into more detail as we have in our regulations. But as I say, they are they should be seen side by side, and hopefully there are some differences, some minor differences, but essentially we're on the same page. But obviously challenges to EU designations will be in the General Court to begin with, and then the main court in Luxembourg. And then, but whereas any challenges to UK designations, which will probably mainly cover the same people and the same entities, will be in the English or Scottish courts. Can we have the next slide, please? Nearly there. So this is the US regime. I'm not a US attorney, and to be frank, I'm not insured to give US advice, so I'm not going to. OFAC is what I mentioned, very, very impressive. They've been going for a long time. They've got a lot more people involved in sanctions than we have, but that's historic. There's nothing bad about that. It's just a fact. It does comprise intelligence officials and lawyers. There's been some debate in the technical media here about the wish of OFTI to try and get some people from the intelligence community to work more closely with them. It's a question of political will and budgets, I would imagine. But right now, they need as much help as they can get. There are substantial remedies available in the US. The SDN list, which you need to look at, all these things are online. So the EU designated list is online. The OFSI designated list is online. The SDN list is online. And you need to check that, or need to find. There are some, it's interesting, in the last 154 days, a number of websites have sprung up offering monitoring compliance services. Up to you whether you use them. They'll be, I would imagine, they're certainly not going to be free. The government produces a free website, so why not look at that? It seems to me quite sensible. Same with the EU, same with the US. So if you're being asked to pay, then you may want to think about that. Just to see whether you're about to deal with someone who's designated, insofar as whether that further service provision or sale of goods is itself contrary to the sanctions regime. That's another matter. Role of lawyers, much less easy for lawyers to get paid in the States, so it's a pretty light touch regime. Could we have the final slide, please? Thank you. It is critical to keep up to date. We've seen that with the accountancy and PR services inclusion in the last 6 days. I'm sure there'll be others that are going to be included, especially if Russia continue to grind out its invasion of Ukraine. You cannot be too cautious. It is extremely, well, you've seen how serious it is. And although obviously the max sentence is not going to be passed every time, or indeed maybe any time, but it's there. And reputationally, it's a killer, I would suggest. You want to be on the right side of the argument. And so the choice between porridge and freedom fries seems to be really easy for me. And as I said, the key takeaway is just know there's a problem. You don't need to know the answer. And thank you. I reiterate my thanks to those who said they were unsure about the 2 poll questions. That's the right. Well, you were right, to the others were right to say yes or no, but actually unsure, that's fine. But insofar as you're unsure, that means it's, even for you, it's on your radar. But even if you say, yes, I can do this, double check, just in case, because the downside is so serious. And essentially, I think you will have to wait for more challenges in the UK and EU courts, which will keep people like me busy. But you as businesses can't wait for that. And you've got to get your houses in order, your trading relationships in order, your supply chains sorted. And they need to, it's totally possible to do business with Russia, if you will, or with persons involved, as long as they're not in an excluded sector. The trouble for everybody who may be exposed is that the sectors that are covered are growing and growing and growing. And so you've got to be very careful.
Thank you very much. We've got lots of questions here, so we might need to move on to questions now, if that's all right.
Sure, absolutely fine.
Great. So that was really informative and interesting. Thank you. I certainly learned a lot, and as I'm sure our audience did, there were lots of surprises in there too. Interesting question from Bob McDowell. If I write a flattering article to enhance the profile of a major figure in a sanction regime, am I violating sanctions? Well,
we go back to press relations services. So, public relations services, which means services provided by a person related to improving the image of their clients and their relationship with the general public and other institutions. So that's what public relations services are. And 54C, big C, then little c, says a person must not directly or indirectly provide to a person connected with Russia public relations services. And you saw what persons connected with Russia are defined as. So it would seem that based on what you said, you've got to be pretty careful about that insofar as you are bolstering the image of a person who is connected with Russia. Obviously, you can bolster the image of lots of other people, but insofar as you're trying to bolster, and you will have seen yesterday, possibly, there was a blogger in the UK, whose name I don't know, who seemed to be bigging up the reputation of certain people who were designated. He himself has now been designated.
So it's rather risky. Andrew Ross has said Russia's imposing sanctions on the world's food system. Will we comply and agree to Putin's terms? What's the difference? Basically, who legally owns the porridge will the world not eat in order to respect sanctions?
That's a very political question, which I can easily duck. If sanctions are imposed by Russia. It's up to us what individuals what they do, but essentially they've, as I understand it, they've imposed sanctions on a number of MPs, for example, and those that haven't been sanctioned are really disappointed. They really wanted to be sanctioned because it just shows that they're on the right side of the argument. Big deal. I mean, a lot of it. I mean, I haven't, to be frank, I'm not able to advise on Russian law. I haven't been looking at the Russian sanctions. Essentially, a lot of it is inward. So you can't come here, you can't trade with us. So what? It may happen. The food issue, yeah, the grain, that's political. I'm afraid it's there are movements afoot. An agreement was signed with brokered by the UN. Whether it works is another issue. But this is the whole point about sanctions: try and bring people to the table. And whether our sanctions, so the anti-Russia sanctions, have brought Russia to the table in terms of Turkey and the UN in relation to grain, I don't know. I'm not in Mr. Putin's head, but yeah, that's not so much a legal question as a political one, and you might want to ask your MP about that. But I would imagine the answer is going to be, we don't care about Russian sanctions.
Tangy Morgan has said, with all the evolving interpretations of sanctions, would not a prudent person simply choose not to have any exposure to Russia?
Yes, and a lot of my clients have done that. They pulled out. There've been, I can give you an example, I'm not going to name names obviously, but where a firm was majority owned by someone who then became designated. That person sought to lower the beneficial ownership, but even so, it became very complex. And so the issue was, despite the fact the designated entity didn't have any control in the terms of the regulations over the company, it came out in the press fairly early on, and they were sort of harassed, which was unfortunate. And so essentially a restructuring was agreed, and obviously a much lower price than would have been prior to the invasion, but just to ensure that the ownership was completely removed. But you also get into a situation like with Chelsea, for example, Chelsea Football Club, where Mr. Abramovich sold that, essentially was forced to sell it. And it was incredibly complex, and I was involved in some of this, not directly, but indirectly. It was incredibly complex to ensure that Mr. Abramovich did not receive a single penny in terms of the sale proceeds to the new American owners, because that was the point of the deal. And not only the point of the deal, it would have been contrary to the sanctions. So, yeah, I think a lot of people are just divesting, and you've seen a lot of companies, McDonald's or whatever, pull out of the US. But also, some lawyers have decided, some solicitors decided to pull their Russian clients. We as barristers don't have that issue because we have a cab rank rule. So if you know what you're talking about and you have the capacity, you basically have to take the ride, essentially, because otherwise people might say, well, I don't like him, don't like her, and then you wouldn't have access to justice. And this has been actually set out in a judgment of Mr. Justice Jack in the BVI, Eastern Caribbean, saying, look, you can't just pull out of cases, lawyers. You've got to, you need a license to get paid, but you're not duty bound to do things pro bono, but actually at the end of the day, everybody's entitled to access to justice. Whether you win or lose is another matter. So you can take the view. There are risks out there, and they're getting higher, I would suggest. And at the moment, no one, as far as I'm aware, has been hung out to dry. But there may be an example made of someone to make sure that the city understands, don't mess with these regulations, don't mess with government policy on that. I don't know, but it's a possibility.
We've probably got time for one more question. If we haven't got to yours today, sorry, because there has been a lot, we will send them directly to Fergus so he can get in touch with you. So Michael Hoddy has said, what evidence has there been of firms changing their business designation in sanctioned industries in order to be able to trade with Russia?
I think, well, I can only speak for myself because obviously a lot of these matters are confidential. I have given a lot of advice which has led to restructuring. Obviously completely lawful, but to ensure that at the end of the day, the people are as compliant as they can be. And what I say to every client that comes along, be they a solicitor, be they a lay client, I say, well done for actually identifying the issues. Goes back to the key takeaway point. Well done. We're going to try and sort it out together. There are no easy answers here, or very rarely easy answers. Let's try and work through. And also, there's no hiding. You need to engage with the authorities. That's really critical. The HM Treasury, obviously Bank of England. I understand someone from the Bank of England may be on the call. We are all in this together. It is not them and us, to the extent that there is a them and us. Obviously, if you're acting on behalf of a designated person, you're trying to challenge that designation, there is a certain amount of them and us there. But insofar as you're working for people who are keen to continue trading with Russia, but lawfully, then everybody should be on the same page, working towards the same goal, which is that in essence, there are certain lawful activities you can conduct in relation to persons connected with Russia, but there are lots that aren't. And insofar as the ones that are, you need to be very careful. It's as simple as, because the aim is very straightforward. It's set out in all the regulations, in all the legislation in the EU and in the US. The aim is to stop this invasion. It's soft power. And so if it hurts Russia more to continue than to stop, and that hurt is imposed in part, not only by the sanctions, but also by weapons or whatever. But if this is part of the armory, and it is, then it will work. But we have to wait and see.
So cautious and prudent is the advice. Yeah. So thank you so much, Fergus. It's been a pleasure to learn from you this morning. And once again, thanks to our wonderful sponsors for making these webinars possible. And equally important, thank you to you, our lovely audience, for your time and contributions today. Sorry if we didn't get time to answer your question. We will send it directly to Fergus so he can get in touch. And we'll also be continuing to provide a comprehensive and diverse range of webinars over August for you. So keep an eye on our website and you can register under forthcoming events. Thank you very much and take care.